I'm trying to catch up this weekend on the mountain of filings that happened last week. Today we're going to update on Perez HIlton's situation, specifically his children ending up on a very public, very popular, very contentious lawsuit. Esra filed a response to his complaint about his children ending up on this court docket, and we're not going to let her play dumb on this. Every attorney well knows that children are the most protected people on this planet. They're referred to by initials. Their names not allowed to be used. Photos are considered a type of identifier. Normally, they are sealed. Attorneys know it, judges know it, even clerks know it. So how did this happen? Before we get into her document, her defense was referring back to this document filed on March 13th, which was the protective order that they held the first hearing that we got to listen to way back when we were babies in this case. If you'll remember, at the time she was fighting for extra protection, this attorney's eyes only designation. It's funny that they're the ones that fought so hard to go beyond the normal protection, and then they are the very ones who did 99% of the doxing that's occurred on this docket. So here's what she quotes to say that it's okay what she's done. She says, well, the order says non-public photographs. It does say that. However, is this the only rule they have to go by? Of course not. We heard Omar on my channel a couple of nights ago, and I'd like to have him back when he can spend a little more time on it. But Omar practices in family court. And in family court, you're dealing with children whose information is always, always protected. These are federal laws. These are state laws. These come before anything. This paragraph she refers to says nothing about it being specific to children. In fact, this was all about Blake and Ryan and their celebrity friends. But still, over and above all of this are the existing protections that have been put in place by the federal government and state governments to protect children. So this just doesn't cut the muster. As one example here, we go to the higher court, the Court of Appeals. In the state of New York, they have this notice put out about court records and how to deal with confidential and sensitive documents. In the first line, it says what we know to be true, that court records are open to the public. And so this necessitates a certain category of confidential information and sensitive information. Children fall under the second one, sensitive information. Sensitive information is considered not appropriate for public view. Notice what it lists as not appropriate for public view. It includes these, but is not limited to Social Security, tax ID, financial account numbers, full dates of birth, exact street addresses, email addresses, telephone numbers, names of minor children, names of children's schools, names of employers, or other information that would identify a person whose identity should not be revealed. For example, victims of domestic violence or sex crimes. As I said earlier, minor children, you can't even use their full name. You have to refer to them by their initials. It then gives a list of 17 types of filing that are automatically considered confidential. This list, it says, is not exhaustive, so there will be others, but these are the absolute necessary types of files that must be confidential. We have youthful offenders, adoption proceedings, and family court. Other things on here have to do with disabilities, illnesses, certain types of victims, but anything involving minor children is automatically considered confidential. And the interesting point is, these are all cases where the children are parties to a case. In this case, Perez himself is not even a party to the case. He's a third party or non-party. His children have nothing to do with this case. When something is confidential, it's supposed to have a cover, and on the cover, the word confidential. It's supposed to then be designated as sealed. How did his children become a part of this docket? This is court etiquette. These are the rules. This is known in every court. Now, we've seen Blake and Ryan bring their kids to events. Not often, I'll give them that. They do try to keep their children out of the spotlight, which I think is great. Except for, bringing their 7-year-old daughter to a movie and making her talk about oral sex between her own father and the man they're taught to call uncle. But for the most part, besides of the graphic sexual talk in a rated-R movie at 7 years old, they do keep their kids out of the spotlight. Not being fans of theirs, I have no idea how extensive it is. I know that I've seen pictures of them when Ryan got his Hollywood star, and Blake was there, and they had 2 kids with them at the time. One was just a small baby. And so that was definitely something where they chose to put their kids in the light. But snaps taken on the street, in my personal opinion, just plain shouldn't happen. It has happened to them, and they've been rightly upset about it. And I've seen people share on X, since this happened with Perez, that Blake spoke out against the accounts that posted pictures of her children and asked the public to unfollow them. I'm in full agreement with that. Protect all children. No matter what we may think of the parents, that has nothing to do with it. Children deserve to be protected. Now, since attorneys are familiar with the laws that are put in place to protect minor children and the privacy laws surrounding children, cases dealing with this topic are few and far between because most attorneys know better and are not going to put children on the docket. But I was able to find a case in federal court where the children's own mother is the one who filed, and she filed pro se, so she didn't have legal counsel there to guide her and properly seal photographs. And that's this case, Erica Lindement versus Bridget Jones. This took place in a federal court in North Carolina. How did the court respond to children being put on the docket? And we see here that this is an opinion, order, and recommendation of United States Magistrate Judge. So in Part 3, he titles it Sealing and Redaction. He says, the federal rules of civil procedure require redaction of the name of every individual known to be a minor from every filing with the court. And he quotes this Rule 5.2 that I went over just a couple episodes ago about privacy. He points out that she did not comply with this requirement, and because of that, he said this failing provides grounds to strike plaintiff's non-compliant materials and require her to refile them with the appropriate redactions. Now this gives us a clue about what Judge Lyman should have done, if not when these pictures appeared, but at the very least, when Perez wrote to the court about it. Because a strike has power behind it. It makes a statement, but as always, she gets to just pull something off the docket that she knows she never should have put on there in the first place, rather than have it stricken by the judge. And I have to say, I feel very unsatisfied about that, as I'm sure Perez does, and probably all of you listening. So that's just the names. Let's get to the rest of it. He goes on, plaintiff's filings also contain sensitive medical information and identifying and/or explicit photographs of the minors. So an identifying photograph would be a photograph that has not been blurred, that clearly shows the child's face. What identifies you more than your face? To protect the privacy of the non-party minors, which is what Perez's children are, the court orally directed the clerk's office to place those materials under seal. The court now reaffirms that order. So this judge took it upon himself when he discovered that this was filed in this manner. He ordered the clerk to place these under seal. So Esra just reaching in and pulling back these photos does not have the same effect as a court striking it and ordering it sealed. We get to see how it should have been done compared to how it was done. And it's just another reason that I give this judge the side eye. Imagine being a judge, given that kind of authority and power. He's been an attorney for how long? He's presided over how many cases? He very well knows what is supposed to happen, just like this judge knows. And this is a magistrate judge. This is a step lower than him. And he knows, and he acts on it without anybody having to ask him to. He just knew that it was the right thing to do. He even goes so far to say, if somebody needs to inspect these, they can't just go inspect them. There must be an opportunity that someone gets to object and deny access to them. He goes on, and he quotes from a case that says non-party movement correctly observes that this court did not strictly comply with the sealing requirements when ruling on the parties' joint motion to seal. Accordingly, the court will do so now when considering movement's motion to unseal. This recognizes that when the appropriate steps had not been taken, that the court, when they become aware of it, they must take those appropriate steps. Quoting from Globe Newspaper Company versus Superior Court for the City of Norfolk, it says, safeguarding the physical and psychological well-being of a minor qualifies as a compelling interest that can outweigh the public's right of access. Another case, Interstate Fire versus Dimensions Assurance Limited, courts have found a compelling government interest in sealing sensitive medical or other personal information, especially when relating to minors. Johnson versus City of Fayetteville, a minor's non-party status heightens the justification for sealing. So there's already sealing when they're a party, as we saw earlier. Non-party, even stronger reason to seal. Now I want to focus for a second on the physical and psychological well-being, because she uses the excuse that Perez puts his children on his own social media, and so they're already out there in the public. But there is a world of difference from a child's perspective to being on your parents' social media and your face showing up on a case like this. Did we forget what the main part of this lawsuit is? I know Blake's main focus is people talking bad about her on the internet. This is a sexual harassment case. Why are children on this docket? What do you think that feels like for kids? Isn't it possible they could be teased for this? It's a very contentious case. There are pro-Blake people, there are pro-Justin people. You got to think about these kids out there in the wild. They have friends, they have cousins, they have playmates, they have schoolmates. And here they are on a sexual harassment lawsuit. What were these people thinking? All of them. Not just the attorney who posted it, but the entire 2 law firms that are working this case. Nobody thought this is a bad idea. Nobody thought, let's cover up the minor kids when we scan this into the computer and file it for the world to see. I mean, take a black marker for heaven's sake. Do not put children on a sexual harassment lawsuit. And what was the clerk thinking? And what was the judge thinking? Look at the moral compass of this judge. Nobody even had to ask him to do this. He just did it. He's like, this doesn't belong on here. This shouldn't have happened. Let me fix it. And let me explain why it needs to be fixed in detail. We've got the father writing to the court saying, hey, this isn't right. And the reaction is just pathetic. What a contrast. He's not even finished. He's still quoting from all these cases. To protect the privacy of the child, who is not a party to this action, the court may find it proper to redact sensitive information, like your face. He gives more details about what happened. Between June 2nd and June 20, plaintiff submitted more than 100 pages of material to the court, including 1 medical report and 10 photographs of the minors. The clerk's office placed the medical report and photographs under seal and identified such sealing in the version of the filings available on the public docket. What did his clerk do? Just put him straight out there. And we see he goes through each docket entry, says the court instructed it, the clerk placed it. He goes on to say the court further finds that a compelling interest in protecting the minor's privacy outweighs the public's right of access to these materials, particularly given that these photographs and records do not affect the disposition of this case. Do Perez's children's pictures affect this case in any way? And Perez asked her, why? She didn't respond. And he takes it so serious, he says no lesser alternative to sealing, such as redaction, would adequately protect the minors. He uses the most secure method at his disposal, sealing. The court will therefore maintain under seal the minors' photographs. He goes on in the conclusion, the photographs of the minors contained in plaintiff's filings remain subject to sealing and redaction. He makes it an official order. Still not done, he says it is further ordered that the minors' photographs, and then he lists which docket entries they are, shall remain sealed. And he puts sealed in bold. This is decisive, appropriate action by a judge. So we've seen the Court of Appeals in New York State show how it's viewed in New York State. We've seen this case to see how it's viewed in federal court. Now let's look at her response. Glancing through quickly, the first thing I notice, because as you know I love looking at the cited cases, do you see any? I don't. Not one single case law is given to support her argument. Do you know why? Because there is none. What she did was wrong. We've got 1.5 pages of excuses and whining, but nothing to support her. And it's all pointing fingers. And that's the inspiration for today's thumbnail, Darvo. The word she loves so much. This is your fault, Perez, because you posted your kids' pictures. I dare say a majority of parents these days post their kids' pictures on a variety of social media venues. By her logic, any parent that does this, their children have no right to privacy, since their parents or their grandparents or their aunt or uncle posted their kids' pictures on Facebook. By this logic, that takes away their right to privacy. Does that make a bit of legal sense? Now let's take it a step further. Let's go to family court. Do they say when they're getting ready to file the document, do they say, let's see, parents, do you have your kids on your Facebook? Oh, you do? Oh, okay. Well, then we're not sealing these files. And that's your fault because you've posted them on social media. She knows the law is not on her side, which is why she hasn't bothered to quote any. Just like she didn't want to respond to our motions to quash or our motions for protective orders, because she didn't then and she doesn't now have the law on her side. This is the laziest, most ridiculous filing I've ever seen. So she mentions him seeking immediate action and asking the court to impose sanctions for purportedly filing multiple pictures of his children on the docket. Let's talk about the meaning first of purportedly. Purportedly has the same sort of meaning as allegedly, and maybe even a tad bit more negative than allegedly. It's something that's been claimed or appears to be true, but isn't necessarily true, or that its truthfulness hasn't been confirmed or verified. She knows this is true. It's on the docket. Why are you using a word like this? And then she says that he lambasts Miss Lively's filings as cruel and calculated and sanctionable, writing, "Shame on Blake Lively and Esra Hudson for exposing my vulnerable young family to such risk. Shame on them." Yeah, shame on them. She knew better when she did it. She knows better now. And now comes the ridiculous excuse-making. She says that Exhibits C and D reflect material that Mr. Hilton has publicly posted and continues to maintain on his own online platforms, including the photographs he seeks to seal. You said it yourself there, Esra. His own. Just because you post pictures of your children on your own online platform doesn't mean I have the right to take those and post them on mine. It's creepy and it's weird. And it's against the rules in the court. And then she says, well, I attached them here because of the biographical information. Okay, Esra, I know redacting is all new to you. But there's another handy little tool called cropping, where you just cut it out altogether and just put the important stuff in there. You could have cropped his biography, and none of this would even be an issue. And then she again stresses publicly accessible. It doesn't matter. A child's photo being on their parent's social media does not negate their privacy in a court of law. Exhibit C is a screenshot of his own verified Instagram profile, which boasts, I think she means boasts, she forgot the S, which boasts 921,000 followers and is publicly accessible. It's a moot point. It doesn't matter. She says his Instagram includes a bookmark titled My Kids that links to videos that he posts of his children. And then she says the only other photograph that includes children, one is too many. Esra, don't minimize what you did. I only stole one thing. I only hit her once. Once is not okay. And you've already talked about two, and now you say, oh, the only other one. But she uses as an excuse for that it's a pinned photograph on his public Instagram page with the Backstreet Boys. And they say neither post indicates the identity of the children in the photograph. A photograph is considered a form of identity. Look it up. If it shows their face, it shows who they are. Once you've seen the face in a photo, you will recognize that person if you see them. What do they put on a milk carton when a child is missing? A photo of their face, because it identifies that child. So don't say that neither post indicates the identity. And then they want to say, oh, he says proud dad. Esra, you make me madder every day. This is pathetic. Now she wants to describe Exhibit D. Where's your legal reasoning? These are bad, I didn't finish my homework type excuses. Where is the law, Esra? I don't want to keep reading you repeating yourself. It's his fault because he posted his own children. Where is the law to support you? Exhibit D is a screenshot of the About Perez HIlton page on his public website. It includes a photograph of him and his 3 children. And again, she says, it doesn't indicate the identity of the children pictured. What does any acceptable form of identification have on it? Your passport, your driver's license, your state ID, your picture. If someone looking to kidnap these kids needs a way to find them, it's not going to be their name, is it? Because kids aren't registered out there. What do they go by? Pictures. More excuses. Miss Lively cited and filed Exhibits C and D on the public docket with a good faith belief that the materials were not confidential. You knew they were underage children, and they're all under the age of 13, which is even a bigger deal, as reflected by their general availability to anyone who visits Mr. Hilton's public Instagram, including any of his nearly 1 million followers. And then, because she has no other law, this is when she refers to that protective order. The protective order that is not specific to children, never mentions children, has nothing to do with children, and does not override your federal and state laws. And then she says he doesn't acknowledge that it's content he himself posted, because it doesn't matter. Nor does he attempt to explain as a matter of fact or law. Where's your matter of law, Esra? Why the public filing of his own publicly available content is cruel or calculated or otherwise sanctionable. But he did, Esra. He told the court because of what has already happened to Steve Sorowitz's family, and because when he was first subpoenaed in this situation, the first thing he did was ask the court for protection for his children. So knowing that someone's child had already been threatened, and knowing that the first thing he did was ask this court to protect his children, you did this anyway. How is that not cruel and calculated? The very thing that was his biggest concern that he voiced to the court, and yet you did it. That's cruel, calculated, because it took a lot of steps to get that to the docket, against everything that you've been taught in law. It strains credulity to credit Mr. Hilton's characterizations, given that he is responsible not only for posting the materials publicly in the first place, wrong, but also, this one gets me, for amplifying Miss Lively's filings to generate his own content on his various platforms. That's what he does. He reports on trending news stories. This is a judicial proceeding. This is exactly the kind of stuff that he has always reported on. And what about all of the ways that you have amplified stuff against the Wayfarer team? Why is that always okay for you and not okay for anyone else? And Blake's not a child. Then it talks about him accusing them of using his children to hurt him and endanger him. And she says that's false and defamatory. No, it's not. Not by any stretch of the imagination is that defamation. Inconsistent with the court's order prohibiting using language that is disrespectful of the parties, their counsel, or the court. You could say that about some of the things that he wrote, but not about this. Saying shame on you for putting his kids on a docket that millions of people all around the world look at every day, that's not false and it's not defamatory. Now let's talk about a very well-known case of an influencer with millions of views, a woman whose entire content was based on her as a mother and her children, Ruby Franke. She started off on Facebook, she ended up on YouTube. She documented most of her children's lives. Now she and this Hildebrandt were discovered to be abusing two of her youngest children, a 12-year-old, and notice, they don't even put the child's name, they say 12-year-old son and 9-year-old daughter. Do you see pictures of the children? Of course not. Even though there are years' worth of these children in every moment of their lives, on video, out there for literally millions to see. Did the court say, well, your mother already has you out there. Millions of people have seen you for years and years and years. We're not going to bother with sealing your names or photographs. Everybody knows your names anyway. Everybody's seen your faces anyway. Is that what happened? No. Not only was the court instructed not to use these children's names or photographs, but the media was instructed as well. They were not allowed to film these children. They were not allowed to show these children. They were not allowed to write their names. Their right to privacy was not stripped because their parents had chosen to put them on display on social media, on a much bigger platform than Perez HIlton has. This is a ridiculous line of reasoning. It is not based on any type of law, and everyone knows it. She loves to throw around the word Darvo. Well, this, ladies and gentlemen, is a fine example of Darvo. Deny, attack, reverse victim and offender. Rather than use law in a response, or just admit you did it wrong, apologize, ask the court to seal it or refile it cropped. No. Well, I only included these, and he posted it first. This is a childish response. And just continuing on with his story, we have him telling the court on August 6th in document 624 that he was served the cross complaint by Esra and that he has filed his motion to quash the subpoena and wants to maintain the venue in Nevada where he lives. Now this goes back to the request to redact and the request for sanctions that she was referring to in her answer. So I put this little section of her document where she says that he doesn't explain, as a matter of fact, or why it's cruel and calculated. Let's see if that's true, or if she's being deceptive to the court again. So he says that she's filed them. He asks her why, and then asks her how is this relevant to this case whatsoever, a question she never answered. Then he demands that she refile without the pictures. He should have asked the court to strike, but he probably didn't know that. And he says she could have done this already, but she didn't. On purpose. It is on purpose. It wasn't accidental. And then again, she said he did it without a matter of fact, or saying why it's cruel and calculated. Right here. Right here. They took away my agency. He has a right, as the parent of these children, to decide where their pictures go. That's a matter of fact. It's a matter of law. Another one. I do not want them on this court's docket in a case that is being watched closely by passionate observers, some of whom are very dangerous individuals. Is that a matter of fact? Is that not the reason why it's cruel? Because she's putting them in danger? Is that not cruel? Does he not explain himself here? If that's not enough, he continues. One of the Wayfarer defendants, Mr. Sarowitz, had an arson on his property. Is that a matter of fact? Is that a reason why it's cruel? As a result of this case, and a criminal was charged with threatening kidnapping. Is that not a matter of fact? Is that not a reason why this is cruel? Additionally, many of the parties and non-parties in this litigation have received death threats. I don't know what she was reading when she said that he didn't explain these things, because it's all right here. And you don't have to be a parent to understand the concern here. I hope he pursues this and asks the court to officially strike that document and put it in order to keep his kids' pictures sealed. She shouldn't get to just reach in and pull it away like it never happened. So what else happened to him this past week? He requested an extension of time to file his opposition to the motion to compel that was filed by Blake. And he gives the reason. He said because he's filed his motion to quash in Nevada, and he wants to wait until they've resolved it. And the judge denies it, saying that he hasn't demonstrated good cause for her motion not to go forward. The one saving grace here is that he does do him the favor of explaining the next steps to him. So he doesn't just say no and leave him not knowing what to do from here. He does tell him what to do. So he says he can argue in his opposition to the motion to compel that the court should defer ruling until the district court in Nevada has ruled. And he lets him know that his motion to quash has not been properly served. And so he tells him he can correct this and repeat these arguments here. So he's just making sure that it's done properly. He tells the clerk to get this order to Perez and advises him to sign up for electronic service so that the clerk doesn't have to mail this stuff to him, which in the end will be better for Perez too because he'll get it instantly instead of waiting days and losing some of his time to respond. Generally, courts do provide more leniency for pro se filers because pro se filers are not attorneys and not familiar with all of the laws or even where to find the rules about how to do these things. So he wasn't altogether awful with this one. And so Perez took the directions from the court. He refiled his motion to quash correctly and then asked for these proceedings to be paused pending the ruling in Nevada. And he does pretty good bringing up the correct rules about venue and such. I don't know how well they'll work. We just saw the subpoena related to the website that was outside jurisdiction. We just saw that, like others before it, be brought under Judge Lyman. And I fear this will be the fate of this subpoena as well eventually, but we'll see. And he concludes it by thanking the judge, which was a nice thing to do because the judge was helpful. And so he thanks him for that guidance and thoughtful approach and kindness. And he tells the court that he will respond once he gets the response from Nevada. And so, I'm going to give Esra's document a 0 out of 10 for not citing any law, for making terrible childish excuses that would never hold up, for using Darvo, and for putting children's photographs on a sexual harassment case docket in the first place. Next time, just apologize and fix your mistake. Because this ain't it.